Our next speaker is Peter J. Flowers, who's a partner in the law firm of Foote, Meyer, Milkey and Flowers in Geneva, Illinois. Pete has, for such a young man, I think he's 41, has established himself 39 years old. Jeez, he makes me feel older than I am. Has established himself as one of our community's premier advocates on behalf of injured parties in our state. He comes off most recently a $24 million verdict in Kane County, which I'm sure is a record. He is a quite accomplished medical malpractice lawyer, among other areas of catastrophic personal injury and wrongful death cases. Pete's a member of the $1 Million Advocate Forum and a member of the Board of Managers, and is presently our third vice president and in line to become our association's president in a couple of years. Would you please help me in welcoming Peter J. Flowers to the stand?
How sophisticated I really am. Good morning. Before I get started on my topic, I wanted to, as Judy's walking out the door, thank her very much for how tirelessly she's worked. You know, she was on trial during this legislative stuff that was happening in Southern Illinois, and I think sometimes up here in Chicago, we don't necessarily appreciate how important it is as to what goes on in Southern Illinois. And Judy raised tons of money, spent innumerable hours doing things down there, and I just wanted to personally thank her and hope everyone does and continues to support her both financially and time-wise in her efforts to ensure that the proper people get elected to help our clients. So thanks, Judy. Back in the back. To your right, I think. At first glance, when I looked at this topic, screening cases, I didn't really think it was all that exciting. We all have our own ways to screen cases, but when you think about it, it's probably the most important decision that a medical malpractice lawyer makes. Because one thing you can never change in a case is the facts. And given the fact that the statistics show us that most cases that go to verdict, even here in Cook County, end up in defense verdicts, we have to be real careful with what cases we take. The cost to do a malpractice case, for anyone that does this, you realize that they're dramatic. The time is enormous. And probably most importantly is the emotional commitment of our clients and their families. If you end up losing a case on behalf of your client, it can be really devastating to them as well as to you personally. So you really have to be selective on what you pick. Our office, and I firmly believe this, really takes cases and puts them into three categories. And these are the only cases that we really consider. And they are cases with good liability and catastrophic damages, moderate liability and catastrophic damages, or minimal damages but good liability, and those are cases that we feel we're going to be able to resolve relatively early on. Anything that falls outside of those categories, I think, are very difficult to take and really need to be evaluated with your head and not your heart, because there's a lot of times we meet a client and we really want to represent that person because they've been wronged. But looking at the statistics, if we represent or take the wrong cases to trial, we will lose. From a screening standpoint, what we do is we really have three levels of screening. Number one is we have the client interviewed, a prospective family interviewed, and that's typically done in my office by a nurse. I'm a big advocate of that because two reasons. Number one is it's very time consuming if you're reviewing and screening a lot of cases to do it all yourself. Number two is I think you get kind of an objective view from someone that isn't always subjectively involved in it. So I know in some senses we're lucky to have that, but I encourage you to get people in your office outside of yourself involved in the initial screening process. So at that stage, we frankly reject about 95% of the cases. And I think when you look at the numbers of cases that you screen, it's probably going to be in the supermajority of the cases that you reject. And you need to if you want to do this for any length of time. If that gets over the initial review hump, we go to the next level, which is obtaining the records, and then we review them in-house by both myself as well as our medical people. And then we probably end up rejecting another 70 to 80% at that stage. If it gets over that stage, we then go to the next stage, which is to find an expert, have the expert review the case, and make a determination for us as to whether he thinks there's a breach and substantial damages. My philosophy on experts at this stage is I think you get the experts or expert that you're going to use at trial. I don't believe in the philosophy that you go ahead and you get these agencies that are out there to simply sign off on 2622s and then proceed forward, because eventually you're going to have to assume you're going to be at trial. And if you get at trial and you've suddenly changed experts midstream, your theory may have changed and you may have missed something either at depositions or written discovery phase. So I think from the very beginning, you search for and obtain who the expert or experts are that you're going to use at trial. Expert-wise, I have adopted a philosophy that an expert really not only needs to be knowledgeable, have a big CV and all that stuff, but actually know how to testify, and know how to convince people, jurors, of why he should be believed or she versus the defense people. So I like to really have seen or at least got major reviews on the experts that I'm going to use before we select them to represent the interest of our clients. A lot of times we frankly go months and months looking at a lot of cases and don't accept a case. And you sometimes get concerned, am I overlooking this case? Should I start accepting more cases? You have to continue to use your head, not your heart, and understand and remember those statistics. If you're outside of Cook County and you go to verdict, the numbers are almost in the 90 percentiles that you're going to lose. So you have to have some confidence that new cases are going to continue to come in. You're going to have an opportunity to review them, and they're going to end up being good cases that you're going to be able to do something that's respectable for your client. Another big factor of the screening phase to me is the whole disengagement idea. When we reject a case, we do it the normal ways, you know, a letter and meet with the client, etc. But I think it's really important to talk with the families when you're not accepting a case as to why you're doing that. A lot of times, from an emotional standpoint, these people believe and get some sort of an emotional satisfaction from being told they don't have a case. A lot of times it's better than when they actually do have a case. They need some closure in their lives, especially in cases of death, that what they did was correct. Even though they may not be medical providers, a lot of times they feel guilty as to what happened, that they should have done more. So I think it's from your own standpoint and from the client's standpoint, it's really important to meet with the people when you reject a case and explain to them, these are the reasons why, and this is how the system is. Also, kind of an indirect benefit of that is we continue to educate the public on why certain cases cannot be brought forward. Why a case where there's a direct and clear breach but there's minimal damages won't allow us to go forward because of the way the law is set up, the way the doctors have lobbied, and things that need to be changed. Obviously, a huge concern that everyone has to take into account is the implication of the caps. So any case after August 25th of 2005 has to be evaluated completely differently than before. The question really becomes is what do you do when you get a 40-year-old housewife who, for whatever reason, has passed away on account of medical malpractice? She doesn't have any economic damages, very minimal economic damages. Do you file the case? Do you wait and see what happens with the constitutional challenge? There is really no true answer to that. What we're doing at this stage is on cases where there is that type of scenario. We'll file a lot of them, but we're also holding a lot of them to kind of see what happens with the caps, because frankly, on a case with minimal economic damages, without clear liability, and you're looking at maybe a $500,000 return, it's going to be very difficult from an economic standpoint to justify going forward with those cases. The last thing I just want to say is, Judy could not have expressed how important it is that we all unify on this issue of going forward with this constitutional challenge. There is a lot of activity from many law firms behind the scenes that are involved in helping out the brief writing, et cetera, that may take place in these cases. So if you get a case, I mean, it's going to be an extremely large undertaking to try and do this yourself. I know a lot of people feel that they can and would like this to move a little quicker, but please let the ITLA office know what's going on so we can have a united front and defeat this unconstitutional legislation. Thank you.